Okay, so I think we'll get underway then. Good evening, everyone. I'm Jason Verhus, a professor at Melbourne Law School and one of the editors of the Frontiers of Public Law. I wish to begin by acknowledging the Wurundjeri people of the Kulin Nation as the traditional owners of the land where I am, here in Carlton North in Melbourne. I'm delighted to welcome you all to the launch of the Frontiers of Public Law, and it's fantastic to see so many of you in attendance, including from so many different parts of the world. And it's a great benefit of conducting the launch online that so many are able to tune in from outside Melbourne. So I want to just begin before we get underway with a few acknowledgements. First, I wish to take the opportunity of this launch to thank all of the contributors to the book for their fantastic chapters. And I'd also like to thank those who helped to make the book possible, including the production team at Heart Publishing and our editorial assistants. And I'm delighted that a number of those who contributed to the book have been able to join us this evening. Welcome. I also wish to acknowledge Dr. Shona Stark, who is a co-editor with me of the Frontiers of Public Law. She is currently on leave and unfortunately unable to join us here this evening, but she sends on her very best wishes. I wish to also thank Heart Publishing for sponsoring the launch this evening and for their long-standing support of the Public Law Conference series more generally. They have been the exclusive sponsor of the conference series from its inception, and Heart have kindly offered registrants of this event a 30% discount on the Frontiers of Public Law, as well as the previous two books in the Public Law Conference series. And you should have received the discount codes in the same email which contained the Zoom link for this event. Lastly, I also wish to thank the Centre for Comparative Constitutional Studies at Melbourne Law School for coordinating this event, and in particular, the Centre Administrator, Connor Foley, for helping to put the event together this evening. So we're here this evening to launch the Frontiers of Public Law, this book. And by way of a brief introduction, the book includes 21 papers by leading scholars, practitioners, and judges from across the common law world, which address the most important issues which have arisen at the intersection of public law and other legal fields. The papers were originally delivered at the 2018 Public Law Conference held at Melbourne Law School under the theme of the Frontiers of Public Law. 250 people from 20 countries attended that event, with over 80 papers delivered over the course of just over 2.5 days. So in terms of the order of proceedings for this evening, the event will be in 3 parts, or acts if you like. So first, Justice Gordon will offer remarks on the collection and officially launch the book. In the second part, myself and 2 fellow contributors to the book, Professors Twomey and Gover, will offer reflections on the book and the papers collected therein, and there will be an opportunity for members of the audience to put questions to us. And in the third and final act, we will be announcing the location and theme of the 2022 Public Law Conference. And we expect to conclude the event by around 7:30 p.m. Melbourne time, in just under an hour and a half. So I'm now delighted to introduce Justice Gordon of the High Court of Australia. It is an honour to have her launch the Frontiers of Public Law. Justice Gordon has been a Justice of the High Court of Australia since 2015. Of particular relevance to the launch this evening, she has, while on the High Court, written a number of important judgments on issues that intersect public law and other legal fields. Before being appointed a High Court Justice, Justice Gordon was a judge of the Federal Court of Australia, to which she was appointed in 2007. Before moving to the bench, Justice Gordon practiced at the Victorian Bar, being appointed senior counsel in 2003. She practiced in state and federal courts in a range of fields, including commercial, equity, taxation, and general civil matters. And she has had a long-standing connection with Melbourne Law School. She has taught at the law school since 1999 and was appointed a professorial fellow in 2015. It is a pleasure to welcome Justice Gordon.
Thank you very much. I too acknowledge the Wurundjeri people of the Kulin Nation as the traditional owners and custodians of the land on which the conference was held back in 2018 and on which land I also sit tonight. I also acknowledge the presence of all Aboriginal and Torres Strait Islanders who are online tonight, and I pay my respects to all of their elders past, present and emerging. I am delighted and honoured to be asked to launch the Frontiers of Public Law, a collection of selected papers that, as Professor Verhus indicated, originated from the third Biennial Public Law Conference, the International Conference held in Melbourne back in July 2018 at the Melbourne Law School, co-organised, as we know, both by the University of Melbourne and the University of Cambridge. I've read the volume, and it's difficult in a short period of time to do the collection of papers justice, but let me try. The contents and substance of this volume stand in stark contrast with the earlier volumes from the first two conferences. The first was titled Public Law Adjudication in Common Law Systems, Process and Substance. The second posed a question, the unity of public law, doctrinal, theoretical and comparative perspectives. This third volume, The Frontiers of Public Law, is different, I suggest, for two interrelated reasons. The location of the third biennial conference, and second, what I perceive to be the changing perception of what is public law. Let me explain. First, the location. The third Biennial Public Law Conference was the first held outside the United Kingdom, the earlier two having been held in Cambridge. And it achieved, I think, one of the important goals of the series, bringing in a wider range of perspectives and participants from different jurisdictions and focusing attention on public law issues pertinent to different countries and different regions. It addressed issues and subjects that were and are of particular significance to Australia, but as well as other countries. And as we've already heard, it attracted participants from about 20 countries and different walks of life, the academy, the judiciary, legal practice, and government. And the content of this volume reflects that. It includes selective papers which discuss and debate issues at the cutting edge of the public law, including, for example, public issues relating to Indigenous peoples, an important issue both then and even more so, I dare say, now. The second is the title of the volume, The Frontiers of Public Law. It suggests that the volume recognises that the traditional view of what is public law no longer holds true, or it's at least pushing the boundaries, the outer boundaries of what has been seen in the past as public law. As the editors point out, and I'm glad they did this, public lawyers have tended to focus on matters at the perceived centre of, or within what might be described as the mainstream of public law, with the vast majority of scholarly writing preoccupied with a relatively small set of well-known topics: legitimacy of judicial strike-down powers, dialogue under bills of rights, deference, statutory interpretation, to which I might add things like the availability of the prerogative of constitutional writs, standing to seek relief. This volume stands apart. Public view is not limited in such, it's not viewed in such a limited way. In part, that change may reflect, even grow out of, I suggest, the statutory changes made by the administrative law reforms of the 1970s. The change may reflect that the state now intersects with the individual in new and different ways, especially where what were previously government functions are now outsourced by privatisation or contract. Change may reflect one response to the way in which the power of the state is applied in particular cases like migration or social security, or that remedies developed in private law context are increasingly being sought in proceedings challenging the exercises of public power. It may reflect that non-state actors now play an increasingly significant role in international as well as domestic affairs, and not just in the national security context. No doubt there are other and many varied causes, but together they have directed attention to issues wider than those traditionally considered as public law. And the volume's 4 parts: public law and international law, public law and Indigenous peoples, public law, criminal law and private law, and finally public law and public administration, make clear, I think, that changes are happening and those parts engage with those changes. The 4 parts recognise that the world with which we now live is complex, multifaceted, multidimensional. They recognise that ideas and concepts are incapable of operating in silos, and that a multifaceted, multidimensional approach to the issues raised by changes in government, economy and society are not only necessary, but lead to much better decision-making and outcomes. Indeed, I'd go so far as to contend that it's never been possible for the law to operate or be conceived as operating in silos. And this volume makes good that proposition. It explains how public law intersects with and is highly relevant in other areas. So what does that all mean? Well, for me, I'm very delighted to say that when a potential associate tells me they wish to practice in public law, and they then tell me that things like Cable, Melbourne Corporation or Brown in an Australian context, or Liberty, Unison or Miller in the context of the United Kingdom, instead of it smiling politely, which I seem to try to do, I'm going to now hand them a copy of this 3rd volume and suggest that they read it from cover to cover. And if they do, I will tell them this is what they will find. They will find that whereas public lawyers in the past have arguably been focused, some might say obsessed, with a small number of legal principles, with the result that the discussion and debate is inevitably at the micro level, and one wondered whether it was even worthwhile revisiting these topics, jurisdictional error to name just one, was worth the effort. This volume takes those important principles and that important work and looks at them afresh. It looks at them not at the micro level, but significantly, and I contend importantly, in the context of the broader world in which these public law principles and ideas intersect as they do with life. Indigenous peoples, criminal law, private law, international law, public administration. And that importantly is not a one-way street, it's a two-way street. Put in different terms and bluntly, as this volume demonstrates, how can you assess or even discuss public law principles of critical importance to our legal systems, to our functioning democracies, without understanding their operation and impact in other areas? Here in Victoria, quarantine hotels provide a real-world, real-time example of that. The failures in hotel quarantine provoked at least one public law scholar to ask fundamental questions about the basis for and consequences of engaging private contractors to secure the confinement of persons under statutory quarantine restrictions on their liberty. Flip it. On the flip side, the volume also demonstrates that it's not possible to address aspects of the law relating to Indigenous peoples, criminal law, private law, international law and the like, without reference to public law principles and its scholarship. As the introduction to the volume repeatedly identifies, the distinctions or divisions are thinning and in some cases have worn very thin. And the distinctions have worn thin because the institutions in the common law world, our respective democracies, have changed. Ideas and concepts that were once confined to private law or the law of obligations are not only discussed, but often at the forefront of what some might describe as public law. Plaintiff M68, the case about detention of persons on Nauru that is discussed in Professor Saunders' chapter, is just one example, and there are multiple others. Where is the line that once was thought to be lie between public law and other areas of law? In my view, it is difficult, if not impossible, to draw such a line, and even if it could be drawn, it would inevitably be required to be redrawn at the very next intersection of public law and, in colloquial terms, what you and I would call life. Indeed, what this volume makes clear is that these new multifaceted, multi-dimensional problems can't be analysed, and solutions cannot be found by reference to no more than public law principles and concepts, just as they cannot be analysed and solved by reference only to principles and concepts of private law and so on. And that is why this volume is so important. It identifies intersections between public law and other areas. It may not identify all of them, but it certainly identifies some of the most important of them. And it teaches us that we need to traverse other areas. We need to get out of our silos and engage with other areas of law, as well as with scholars, judges, and practitioners from these other areas. We need to go to the edge, to the frontiers, and question whether what lies at the core applies at the edge or requires reconsideration because of what we find at the edge. Or adapting the way in which it was put by the editors, the different parts of the book should be read as conversation with one another. The different parts are in conversation with one another, and if you don't read each paper in each part, if you don't listen to what is being said in each paper, then you're only hearing part of the conversation, not the whole conversation. And the analysis is likely to be therefore to be incomplete and inaccurate, and in the globalised world, dangerously so. This volume is, I think, best described as a toolbox of intersections and ideas, a superbly indexed toolbox of intersections and ideas. It is essential reading for all scholars, judges, and practitioners, and if I may be so bold, for anyone interested in the world in which we now live, a world with fundamental shifts in government, economy, and society. It's difficult to think of a volume of legal papers with the world's public law in its title that would have, even 10 years ago, included indexed entries to climate change, contracting, compensation, double jeopardy, equitable relief, Indigenous values, insurers, ISIS, lethal force, outsourcing, trustees, to name just a few. The boundaries are no longer able to be drawn simply by reference to legal principles. Rather, they must be drawn by reference to what is happening and why. And this volume, this 500-page toolbox, is essential in seeking to answer those important questions. What is happening? Why is it happening? And what just might be the consequences and the remedies? I congratulate the authors of the papers. I congratulate the editors of the collection of the papers, and I have great pleasure in launching the frontiers of public law.
Thank you very much, Justice Gordon. We are really grateful to you for officially launching the book and for your thoughtful and also thought-provoking reflections, which have served to really tease out the core themes, the nub of the collection and what we were trying to achieve with it. And you've offered a lot for us to take away and contemplate further. And I'm particularly pleased that the book will be required reading for each of your associates going forward. So thank you very much again. It really is an honor to have you launch the work. So we'll now proceed to the second part of the event, which is a discussion by contributors to the book. And this panel will offer reflections on key aspects of the book, core themes, and the research agenda going forward that emerges from this work. And some of those points have already been thoughtfully touched upon by Justice Gordon. So I'm delighted to be joined for this panel by two fellow contributors to the book who are distinguished figures in their respective fields. Professor Anne Twomey, Professor of Constitutional Law at the University of Sydney, who is a leading expert in constitutional law, and Professor Kirsty Gover, who is a Professor of Law at the University of Melbourne, at Melbourne Law School, and a leading expert in the law relating to Indigenous peoples. So I'm first going to introduce the book and touch upon its basic premise and discuss briefly two frontiers addressed in the book, namely the frontiers between domestic public law and international law, and between public law and private law. Professor Twomey will then consider the frontier between public law and public administration, and Professor Gover will then address the frontier between public law and the law relating to Indigenous peoples. So these presentations will then be followed by a Q&A session where the three of us, the members of this panel, will answer any questions that the audience may have, and that the way we're going to take questions during that session is via the Q&A function, which you can find at the bottom of the screen, and Connor has via the chat set out some instructions for its use. So let me begin then. Much legal scholarship has focused on issues that arise within a single field of law, the vast majority of legal scholarship, such as topics within public law or topics within the law of tort, for example. So the frontiers of public law differs in that it focuses attention on issues that arise at the intersection between public law and other fields. So for example, issues arise at the intersection between public law and private law, or between public law and criminal law, for example. So one might frame this as an inquiry into issues that arise at public law's boundaries, but we prefer to frame the inquiry as one into public law's frontiers. And the reason for preferring the language of frontiers to boundaries is that we not only wanted to examine the constraints or limits on public law, but we also wanted to examine the possibilities for legal development and thought where public law intersects with other legal fields. So there were two prompts for considering public law's frontiers that I want to discuss briefly. And one is that which was flagged by Justice Gordon, which is that public lawyers have, and this is perhaps a feature of all legal fields, tended to focus on a relatively small set of well-known topics at the perceived center of public law. Things like judicial strike-down powers, proportionality, deference, statutory interpretation, and notions of dialogue. And the terms of the debate for each of those topics are relatively well established, and the scholarship in regard to each of those topics is increasingly specialized and detailed. So these topics, which we might say are at the core of public law scholarship and thought, are no doubt important, and that's why they've garnered so much attention. But at a certain point, the law of diminishing returns kicks in. What have so far garnered less attention are issues which cut across public law and other fields, such as tort or criminal law or the law relating to Indigenous peoples. These points of overlap between public law and other fields have too often, I think, been a blind spot in our understanding of public law, and it is a core aim of the collection to enhance our understanding of such cross-cutting issues. Importantly, it's often the case that when one considers these points of intersection, one learns the most about the nature of particular fields. So for example, it's in relation to issues that it is in relation to these sorts of cross-cutting issues that one is forced to confront what, if anything, renders public law distinct from other fields. As such, examination of these issues that arise at the intersection of public law and other fields has great potential to provide the most telling insights into the nature of public law as a discipline. And indeed, as Justice Gordon alluded to, after one reads the chapters in the collection, one may very well come to question whether public law is a distinct discipline at all. So the second prompt for considering public law's frontiers is that many of the most important and challenging issues today are arising at the intersection of public law and other fields. These issues cannot be addressed without the input of public lawyers, but equally, they cannot be adequately addressed solely through the application of public law tools. So, for example, the issue of how to regulate government contracts is one that implicates public law, contract law, and issues of public administration and political accountability. More generally, there are important questions which are increasingly arising over the extent to which government ought to be governed by the same private and criminal laws as apply to private individuals. A normative concern to recognize and protect the interests and culture of Indigenous peoples is one that cuts across established legal categories. It's a concern that implicates public law, property, tort, equity, succession, contract, and many other fields. Similarly, the rise of automated decision-making is one that belies any neat compartmentalization. Consider the recent robo-debt fiasco here in Australia, which concerned a government automated debt system, which resulted in claims in public law because aspects of the system were unlawful, in restitution for repayment of unlawfully demanded monies, and in tort for psychological harm suffered by those subject to the scheme. So a core aim of the collection is to identify such cross-cutting issues, to draw out their complexity and multidimensional nature, and to work towards solutions to these issues which are increasingly arising before courts. The collection also aims to foster a conversation between specialists in public law and those who are specialists in other fields, on the basis that applying different disciplinary lenses to complex problems can only enrich our understanding of those problems and move us closer to workable solutions. So those are the prompts for the collection and for focusing on issues that arise at the intersection of public law and other fields such as private or international law. Let me now go on to outline what I consider to be one of the core themes that emerges from the chapters in the collection. Law regulates certain phenomena, such as government, social life, the market, technology, the international order, and so on. Over time, these phenomena have tended to greater complexity, and in turn, there are significant ramifications for public law practice and thought. In particular, we see binary distinctions, such as those between public law and private law, or domestic public law and international law, breaking down as they rub up against the increasingly complex nature of the modern world. As law adapts so as to comprehend the increasing complexity of the subject matter it regulates, this has the consequence of challenging and breaking down established legal categories or legal boundaries. Put another way, as the activities subject to legal regulation, such as government, social life, and the market, become increasingly multifaceted, then so too must the law. Consider the division between public law and private law. The legal division is premised on there being a meaningful and determinate division between public life and private life, with public law regulating the public sphere of life and private law regulating the private sphere of life. But it's nearly impossible today to identify a distinct public sphere of life and a distinct private sphere of life. Rather, the two spheres have been intermingled in a process that some have analogized to the scrambling of an egg. Government, the quintessential public institution, is increasingly organized around private sector models which emphasize market mantras of efficiency and value for money. And government increasingly operates through private providers and according to private law techniques such as contract. On the other hand, it's increasingly recognized that private actors such as corporations may wield significant power, and possibly more power than governments. In turn, there are increasing societal expectations that private entities be regulated in the public interest, and ideas of checked power, democracy, and the common good, which we might traditionally associate with the public sphere of life, are increasingly prominent in the context of market-based activity. Further, much of our private lives is increasingly played out in public on social media, and it's recognized that what happens in private relationships may be of public concern, as illustrated by the Me Too movement. As such, we are not confronted with a neat division between the public and private aspects of life, but rather reality is more messy and complex. As any division between the public and private spheres of life is challenged and begins to break down, so too has any firm division between public law and private law. As that legal division has been worn down, legal ideas and norms have flowed more freely between public and private law. So, for example, we increasingly see judges reading across administrative law norms to regulate discretions conferred under contracts or under trusts. And we increasingly see tests resembling proportionality, a public law technique, arise in private law settings. On the other hand, we increasingly see private law concepts, such as the notion of individual rights, characterizing public law. We've seen the rise of fiduciary duties that emphasize protection of weak from strong across both public and private law, reflecting that the regulation of power is a concern that transcends any notional public-private division. Now, we see similar trends in relation to the traditional distinction between domestic and international law. Over time, it's become increasingly difficult to identify a determinate boundary between domestic public law and international law. And reflecting this, for a long time, we've seen international norms flooding into the domestic order. But increasingly, we are seeing the reverse effect as well, as the chapters in the book document. That is, we're seeing the increasing influence of the domestic on the international. As any meaningful division between domestic and international law has worn thin, we've seen concepts developed in domestic public law, such as the ideas of administrative law and constitutional law, increasingly transcend the domestic sphere and shape thinking at the international level. Thus, the emergence of the fields of global administrative law and global constitutional law. More generally, as illustrated by Brexit and America's, shall we say, combative approach to international relations and trade over the last 4 years, local concerns have been powerfully asserted in a way that's had significant ramifications at the international level. As such, the idea of systems of domestic and international law being discrete and existing in parallel is long gone, if it ever existed. So a golden thread running through the chapters in the book is a trend towards greater complexity, and with this, a concomitant breaking down of familiar legal distinctions and increasing cross-fertilization and interconnectedness between public law and other fields. Lastly, a question arises as to how academics, practitioners, and judges and other legal actors ought to respond to these trends towards greater complexity and the increasing rise of issues that transcend any one legal category. One response is to reassert traditional distinctions. So, for example, a number of leading scholars in public and private law have in recent work strongly reasserted the division between public law and private law. These accounts are interesting, but it's difficult to know what they offer in a practical sense, as they are completely at odds with reality. Such accounts are in truth a defensive reaction to the reality that the public-private division is collapsing. Another type of response is reductionist and is best illustrated by the use of regression analyses that seek to reduce complex legal phenomena to a set of variables. The simplicity and neatness provided by such quantitative models may be comforting in an age of increasing complexity, but there's an open question whether such studies carry forward thinking in a meaningful way. And finally, a third type of response is embodied in the contributions to the frontiers of public law. That is to recognize the increasing complexity and interconnectedness of public law and associated fields, and to endogenize that complexity into our accounts of law and in our arguments for reform. If such an approach is taken, we'll be in a position to develop arguments that can be mobilized in the world and are workable and responsive to the multifaceted nature of complex issues. We in the academy and in practice need to be open to the need to develop new skills and understand fields of law beyond our immediate area of study. The new issues that are arising cannot be solved by knowledge derived from public law or any other one field of law. We need to develop a set of tools that incorporate learning from a range of fields and talk and collaborate with those working in different fields. The contributions to this book embody such an approach, and as such, not only do the contributions provide deep insights into specific topics that arise at the intersection of public law and other fields, the contributions, importantly, are emblematic of a type of scholarship and way of thinking that's required if we're to fully understand and resolve the new issues that are arising at the frontiers of public law. Okay, thank you. So now I'll pass on to Professor Twomey to address the divide between public law and public administration.
Thank you very much, Jason. So what I thought I'd do in looking at these chapters is to put them in the context of what has actually happened since. I mean, I know these chapters are very recent. The Heart was really speedy in getting out the book. But as we all know, 2020 has been, shall we call it, interesting times in the sense of the Chinese curse of living in interesting times. A lot has happened, and in looking at these chapters again, it brought to mind different sorts of issues that are quite contemporary that are raised effectively by these chapters. So the first chapter in the section dealing with public law and public administration is the one by Ken Hayne, which I think is a really useful introduction. He raises a lot of provocative things in the beginning, which would be actually been really good if he could have got into all of them, but in the end confined himself to dealing in detail with issues concerning the outsourcing of public services to the private sector through contracts. And as Justice Gordon mentioned, that obviously has been particularly pertinent recently in terms of contracting private security guards in hotel quarantine hotels in recent times in Victoria. And as we're all very conscious, this leads to problems of accountability and also problems in relation to matters like judicial review, freedom of information, how you make these private bodies accountable in the same way that the public sector would be if it was performing the same services. And one thing that arose from that chapter, I think, was observations about separation of powers and how they frequently primarily focus on judicial power and its intersection with the other powers, but that intersection between legislative power and executive power is actually very rarely addressed. And we can see the problems that arise from that, again, in recent experiences as a consequence of the pandemic. So one that I've been looking at recently is the issue of the Australian Defence Force and the extent to which they can be used in providing aid to the civil community. And this leads to all sorts of really interesting problems in terms of the intersection between the legislative power to authorise the Defence Force to do things, so statutory provision of executive power, and the prerogative power, which is how this is primarily exercised. So in Australia, there's no statutory power for the Australian Defence Force to provide aid in relation to pandemics or natural disasters. And the reason there's no statutory power is because there are significant doubts as to the legislative head of power for the Commonwealth to provide such. But instead, bizarrely, the Commonwealth relies on prerogative power or implied nationhood power to get them there as an executive power even though they think potentially they don't have a legislative power under the Constitution to do it, which is a rather bizarre approach. But anyway, that's what happens there. And the other thing that it brought to mind as well, in terms of that problem of the intersection between executive and legislative power, concerns ministerial prerogative to act in relation to the administration of the public service. And we saw that particularly in the sports rorts affair. And you'll see I mention this a bit. You probably think I'm completely obsessed by it, but I think it is a spectacular case study of almost everything that can possibly go wrong when you're dealing with issues of constitutional administrative law. So from a public law point of view, sports rorts covers everything, and I hope we all end up teaching it no end, because I think it's something that does need to be repeated. And one of the most striking things I found in relation to that whole controversy was the extent to which the minister just seemed to assume that she had ministerial prerogative power to do whatever she jolly well liked in relation to these grants, because she was the minister and it was in her portfolio, and that was the end of the question. No understanding at all about the scope of her powers, no understanding about the fact that when you have a statutory body, that's an independent body which has specific powers under statute, and where the minister's powers are limited by those statutes, that might somehow impact upon what she can do. And I think also quite shocking that she's not getting, or she was not getting, advice from public servants, lawyers, providing advice to the government as to the extent of her powers and the ability to exercise them. So I think there needs to be a lot more work and explanation of that intersection between executive power and legislative power, because clearly the people who are actually exercising executive power at a very high level have almost no understanding of the basis of their powers and the limitations on it. And that for me was the big lesson that came out of the whole sports rorts debacle. Ken Hayne also raised issues concerning justiciability and standing in relation to the application of appropriations, a special reference there to the Combay case and the Wilkie case. I have to say, again, a bit of criticism, this time directed at the court. I do not think that those cases are examples of the High Court's shining hour in relation to jurisprudence. I actually think those cases have been really damaging to the ability of Parliament to be able to exercise powers to properly scrutinise and control appropriations. And I also think there's a bizarre conflict between both Combay and Wilkie on the one hand, and the High Court's approach in relation to the Pape and the Williams cases on the other, where the court stressed the importance of Parliament and its role in relation to scrutiny, in relation to expenditure. We have this strange disjunct between, on the one hand, appropriation and the other hand, expenditure that's going on. And if anyone's looking for something that a student could really get into in terms of studying, I think that's a really important area that needs to be properly explored. After his paper came mine. So mine was about transparency and secrecy in relation to the executive of high prerogative powers. Concern about the increase of secrecy, particularly in relation to exercise of powers that deal with matters like the reserve powers, so fairly high and fairly important exercises of power by the Queen and the Governor-General. But also about the fact that, on the other hand, there are some attempts to be a little bit more transparent and to clarify the types of conventions and rules that apply by putting them all down in cabinet handbooks. Now, there are significant problems about the way this all works, partly because on the secrecy side, you're not actually giving people access to the type of documents that would show you the types of precedents that give rise to the conventions, so that when you start trying to clarify what the conventions are, in your cabinet manual, basically this is all a black box. This is all under the control of the executive. This is the executive's version of what they want the powers to be, without actually telling what's really happening. And that is very problematic, because we end up with assumptions about conventions that are just completely and utterly inaccurate and do not represent reality. And once you get to a point where scholars and the public and everybody believes things to be working in one way, and there's reality which is completely different, then that becomes very dangerous. And that's where we end up in crises like the 1975 dismissal crisis, where there is a disjunct between what actually the players believe or understand the rules are and what the public and the media believe them to be, and academics as well. So certainly needs to be a fair bit of work there. In terms of what's happened since then, the Hocking case, I think, is really interesting. So we've had the High Court now say, yes, those documents are documents that under the statute are accessible. And in releasing those documents and making them public, I think that in itself has been quite interesting. Yes, there has been a divergence in views as to what those documents actually mean. Some people are insisting on maintaining their view as to what would have been in them, despite actually reading them and finding out it wasn't in there, but doesn't really stop some people from continuing to say it's there. But nonetheless, I think that what it did show was that the secrecy was all a bit pointless, because, you know, all the stuff that they were trying to hide actually, when released, showed that the palace wasn't really doing anything at all there. At most, what it was showing is potentially its own redundance. A lot of the argument you see in terms of the reason to maintain the monarchy is that the monarchy somehow gives us some magical stability. Well, what we actually saw in this correspondence in relation to the most constitutionally traumatic time that Australia has been through is that the monarchy wasn't really taking a role there at all. It certainly wasn't out there trying to bring down a government, but equally it wasn't out there stopping it or giving stability or really doing much of anything at all. So to the extent that it plays in legitimately to a Republican argument, it actually really just plays into a sort of a redundancy argument in terms of, well, if you're not actually there doing anything, what's the point? So maybe it gives that kind of an argument, but I don't think that it did anything to threaten the monarchy or its existence in any kind of substantial way. Other developments there, secrecy. I think what we have seen in recent times is a massive increase in the secrecy obsession, and we've seen that particularly through the creation of National Cabinet. Now, as many of us will realise, National Cabinet is clearly not a cabinet. They're misusing the terminology. Clearly, it's not a cabinet because it's comprised of people who are not responsible to the one government and the one parliament. They are people responsible to separate governments and separate parliaments. Therefore, it is not a cabinet. So why call it a national cabinet? Well, it's extremely obvious why they're doing it. It's all about secrecy. So otherwise, intergovernmental bodies, yes, there are secrecy requirements under freedom of information, but you have to apply a public interest test. But if you're the government and you can't be bothered with the whole public interest business and applying a public interest test, you just want absolute secrecy, then you make something into a cabinet committee and then you've attracted it without having to go through all that sort of, you know, transparency business and applying tests, etc., etc. And so that's what's going on. And it's not just in relation to National Cabinet. They did it as well to the, I always forget the name of the thing, HPPCs, the Health Committee thing. And so they've done it in relation to that as well. And also the committee that's advising the Commonwealth in relation to COVID-19. And you can see this now. This is going to expand massively. You know, this sort of secrecy stuff started with whatever happens on the water is going to be secret. You remember all that business? Well, now it's expanded massively. And it will continue to expand until such time as a court actually says, well, you can call it a national cabinet, but in reality, it's not. And it does not attract cabinet secrecy. So, you know, fingers crossed for that one. Okay. The other interesting thing there in terms of cabinet manuals, again, which I addressed in my paper, is that they have recast the Commonwealth's Cabinet Handbook in order to support that argument of secrecy, which again, I think is inappropriate. And this again raises a point that Ken Hayne raised in his paper, and that is about the use of guidelines and manuals, etc., as soft law. And we've seen that increasing recently as well. And the ineffectiveness of this soft law. Look at the ministerial standards and how effective they've been not. So absolute classic again in relation to the Sports Rorts affair. Even though Bridget McKenzie was required to resign because of one small tiny conflict of interest, the review done by the Department of Prime Minister and Cabinet in relation to that was utterly appalling. So the fact that the people who are supposed to be giving effect to and scrutinising action under these sorts of things have failed to do so is in itself quite worrying as well. Anyway, getting off me and moving quickly on to the other people and their chapters. Catherine Kovac's chapter looked at the problem in the United States that arises where the courts impose burdens on rulemaking by executive agencies. And when that combined with the type of legislative paralysis that you get in the United States resulted in effectively greater presidential authoritarianism. And this is really a case of be careful what you wish for, because on the one hand, people would wish the judiciary to be quite active in terms of bringing that kind of accountability to agencies. But I think what's being quite strongly put in this particular chapter is that in itself can be problematic if the agencies find their hands tied, if the legislature is not working effectively because of different majorities in different houses, etc. And what do you end up with? That is an authoritarian president. And to bring that again into the modern day, this is what we're seeing with the pandemic. The pandemic has certainly resulted in greater authoritarianism in countries across the world, particularly through the use of delegated legislation, particularly in circumstances where you have Henry VIII type clauses where your delegated legislation can override statute, particularly when parliaments are not sitting, particularly when they're non-disallowable instruments, and particularly when, because they're non-disallowable instruments, parliamentary committees aren't able to review them. So lots of problems arising in that field today. Shona Wilson-Stark's chapter does a deep dive into one of the mysteries of UK administrative law, which is how to balance the need for policy consistency and the fulfilment of legitimate expectations on the one hand, against the non-fettering principle, which allows all factors to be taken into account. And I think her approach in reconciling them and using them as tools towards an outcome is in some ways quite similar to what the High Court's been doing recently in relation to things like the structure proportionality test. In the end, what you really need to be doing with these things is making sure that the rules themselves are not the end. You know, you shouldn't be obsessed with applying the rules as an end in itself. The rules should be there as tools to achieve the end that you need to be achieving, whether that be procedural fairness or whether it be you know, complying with the constitutional type of implication. So I think her chapter is really important in that regard. Jennifer Razzo's chapter explores the really practical area of decision making on the ground, doing so on the ground by administrators in Canada, which are the tens of thousands of decisions that are made every day by ordinary public servants, which really affect people's lives, but never come anywhere near a court or some kind of review body. So she's looking at frontline administrative practices, and which she identified through empirical research. And this is an area where in law, we're actually really bad. We do not do this very often, but I think it is incredibly important to ground theory in what is happening on the ground in reality. I try and do that with constitutional law. It's a bit more esoteric because I've got to try and find out what governors general and queens have been doing. Slightly difficult, but this is much more real world practical stuff. And the last chapter is by Richard Martin on the application and interpretation of the UK Human Rights Act. And it points to the fact that public servants are also interpreters and appliers of the law. And again, I think this shows up something really important, and that is that we often abdicate to our courts responsibility for making the decisions about the interpretation and application of the law. But in the real world, it's all of us every day who make decisions about whether what we're doing is legal or not. You know, if you go to the supermarket and you buy something, you always have to make the decision, am I going to pay or am I going to do something like illegal, like steal it? There is this sort of notion that we sometimes get through separation of powers that only the judiciary can make decisions about what is legal and what is not. And I think that's wrong. We all make decisions about that every day. But most importantly, the executive needs to make active decisions about the legality of its conduct. It cannot outsource this to the courts to make those kinds of decisions, because usually no one will bring those actions before the court, or there will be no standing or whatever. Public servants need to actively consider whether what they're doing is legal or not. And I have to say, the one thing I find quite disturbing these days, particularly in Canberra, is this idea that you make your assessment on the basis of constitutional risk. And what does that mean? It means, are we going to get caught? Is there anyone with standing to bring proceedings to challenge this? Does anyone have an interest in challenging this? And if they don't, then let's go ahead and do things that we know are probably unconstitutional, but unless we're going to get caught, we don't care. From my point of view, I think that's completely and utterly wrong. Governments have a responsibility to comply with the rule of law, to act within the Constitution, and no, you should not be advising on the basis of constitutional risk. You should be advising on the basis of what the law is and whether what the government is doing is constitutionally valid or not. So Martin's chapter looks at this from the perspective of Northern Ireland police officers applying human rights when policing parades and protests. And again, I think we've seen this in our real lives in recent times in Australia, where we've been looking at the Black Lives Matter protests that have occurred during the pandemic. So it raises those really difficult issues of how to manage that by, on the one hand, protecting public health, but on the other hand, allowing free speech. And that's a real challenge for police, and it needs to happen on the ground. It's the people who are there who are making the decision as to what to do. We had recently real problems about this at University of Sydney, where we had protests on the university grounds, and one of my colleagues, a professor at the Sydney Law School, was physically knocked to the ground twice by police officers for doing no more than observing a student protest in behaviour which, as best I can see, is completely and utterly inappropriate. So there are good reasons why public servants and police need to be well trained in relation to issues concerning human rights, as well as protecting and giving effect to the law. So that's my say on the various chapters, all absolutely fascinating, as Justice Gordon pointed out, and I do recommend them to you all. Thank you.
Yeah, thanks, Jason, for the invitation to be here and for the opportunity to contribute to such a wonderful volume. I'd like to acknowledge that I'm on the land of the Kulin Nation and pay my respect to their elders past and present. And I'd also like to acknowledge and pay my respects to the Kati, Waimoy and Ngāi Tahu people of Aotearoa, New Zealand, on whose land I was born and raised. So in these brief remarks, I propose to focus on just one quite broad theme that I think connects all the chapters. They all deal with it in some way, and that is the need for settler law to properly respond to Indigenous assertions of agency, and in particular assertions that go to their status as polities in their own right, with the capacity to negotiate the terms of their relationship with settler governments. And I think all of the authors in this section and various idioms also see that a just response will require settler law to give up some of its conceit of comprehensivity by restraining its reach in matters that implicate the authority and governance of Indigenous polities. And we might call these matters broadly Indigenous public law. And this is an interesting theme to me because I think perhaps for some, and certainly for me, the word frontier connotes a sort of forward movement. And of course, frontier has a whole another set of connotations where Indigenous peoples are concerned, notably a long history of frontier resistance and violence. So I wondered, as I was reading the chapters, if with respect to this particular intellectual frontier in the book, that what is being proposed in these chapters is that public law be developed in ways that include its withdrawal from fields in which it has improperly occupied in the past, which I think brings together the intellectual and the sort of physical metaphors attached to the idea of frontiers in quite a paradoxical way. So the chapters emphasize in different ways the necessity of public law developing and inculcating the arts of restraint, humility, and deference on the part of settler officials, with a concomitant recognition of Indigenous expertise, authority, and sovereignty. So to my mind, taken together, these chapters remind us that public law is fundamentally concerned with power and perhaps especially concerned with the conditioning of power. And in that respect, I'm reminded by the call in Australia's Uluru Statement from the Heart for a voice to Parliament, makarata or treaty, and truth-telling to alleviate the torment of powerlessness experienced by Australian Aboriginal and Torres Strait Islanders by enabling their law and sovereignty to coexist with that of the Crown. Now, I thought, having set the scene and drawn our attention to that theme, that I would step through some of the core features of each of the chapters in this section as I see them. And I'll do this in the order in which they appear in the book. So first, the Honourable Justice Matthew Palmer of New Zealand's High Court contributes a chapter called Indigenous Rights, Judges and Judicial Review in New Zealand, in which he considers the role of the judicial branch in protecting Indigenous rights in Aotearoa. And he provides a detailed and insightful analysis of 53 judicial review cases involving the Treaty of Waitangi. He says the modern reinterpretation of the treaty, which involves the Waitangi Tribunal, Parliament and the courts, exemplifies constitutional dialogue. He says, while many grounds of judicial review in treaty law are argued and put together in quite complex compositions, that reasonableness looms large amongst the grounds that are successful when litigated. And he concludes that in its emphasis on reasonableness and good faith, this emergent reinterpretation of the treaty in public law, quote, might have come to mirror the substance of judicial review law, and suggests that that's likely because process and reason are, he says, after all, the essence of good relationships. In the next chapter, which is titled Coming to Terms with Communal Land-Related Decision-Making by Aboriginal and/or Torres Strait Islander Peoples in a Public Law Context, the Honourable Justice Debbie Mortimer of the Australian Federal Court offers a very rich and reflective account of the challenges that she faced as a judge in two cases decided in 2017 and 18 respectively, each of which raised difficult questions about how a court should approach the review or assessment of communal decision-making by traditional Indigenous peoples and communities. Justice Mortimer asks whether, in such reviews, there may be ways that courts can better empower Indigenous people to speak for themselves through evidence rather than through non-Indigenous methods, such as expert evidence. And she has in mind, in particular, the role played by non-Indigenous anthropologists in Indigenous governance. She also wonders whether the courts should afford greater recognition and support to decision-making methods that depend on traditional law and custom, which can be quite complex, that are not properly reducible to majoritarian decision-making methods that we're familiar with in settler law. So she calls on courts to show leadership in these areas, noting that this is a core part of empowering Indigenous peoples to be in charge of their own decision-making processes, which I think is a very powerful challenge at this particular frontier. The next chapter is by Associate Professor Mary Liston of the University of British Columbia. And she takes up some of the challenges raised by Justice Mortimer, but in the Canadian context in her chapter, which is expertly argued, entitled Representing Jurisdiction, Decolonising Administrative Law in a Multi-Jural State. And in this chapter, Associate Professor Liston explores the relationship in Canada between administrative law and Indigenous governance law. She seeks to investigate how this relationship can be renovated or restructured in a way that recognises and reinforces Indigenous law. She says this might be possible if it is understood, and I'm quoting, the special role of administrative law is to check the power of the Crown and constrain both the structured and unstructured discretionary powers the Crown exercises in public law. Echoing the emphasis perhaps that we see in Justice Palmer's chapter, Liston argues that in the review of Indigenous governance arrangements, which is still possible in Canadian law, even when those arrangements are customary in character, she says reasonableness should be the presumptive standard. And in concert perhaps with Justice Mortimer, she also urges courts to work to, quote, confirm Indigenous expertise over Indigenous norms. In my chapter, which is next in this section, it's called From the Heart, the Indigenous Challenge to Australian Public Law. I consider the recent history of calls for constitutional recognition of Australian Indigenous peoples in the Australian Constitution by putting these calls in comparative context. And my aim in this chapter is to show that the stark divergence between the approach taken by Australia's elected officials and leaders on the one hand and Indigenous peoples on the other reveals competing visions of the composition of the public that is to be served by public law. And the model currently promoted by our political leaders, our settler political leaders, the Australian public, comprises a single people exercising popular sovereignty to whom the state is ultimately responsible. But as I argue in the chapter, settler states are multi-people states. And not just that, they are multi-people states in which Indigenous peoples are tiny minorities for the most part. So in the chapter, I look at some public law adaptations in New Zealand and Canada that appear to me to be counter-majoritarian devices, treaty, bills of rights protections, and fiduciary and trust responsibilities to Indigenous people. I suggest these are all useful and necessary, but not quite sufficient. They do bring us closer to the ideal of constitutional equality between peoples by emphasising the distinctive relationship that exists between the state and Indigenous peoples, a relationship it does not have with the settler populace. None of these devices yet exist in Australia, hence the need for the voice to Parliament and for makarara or treaty is a modest first step towards them. In his chapter called Public Law Legitimacy and Indigenous Aspirations, Dr. Harry Hobbs of the University of Technology, Sydney, turns our attention to the design of institutions that empower Indigenous peoples to have their voices heard in settler government decision-making, providing a very rigorous case study of the form and function of Australia's now abolished Aboriginal and Torres Strait Islander Commission that many of you will know of as ATSIC. And he addresses in his chapter the tension in Indigenous scholarly thought between the necessity of preserving autonomy by refusing recognition on the one hand, and on the other, the real power that can be gained by leveraging state institutions and resources. In line with the other authors in this section, Hobbs argues that whatever approach is favoured amongst these two broad strategic positions, Indigenous peoples and communities should be empowered to make the decision themselves. And he also makes the useful point that more than just passive consent is necessary, active support is required by the standard of legitimacy he deploys that he sees in many of the claims made by Indigenous peoples in Australia. Now, finally, the last chapter in the section that I've been asked to address is a chapter by Professors Jacinta Ruru and Andrew Geddes of Otago University. It's titled places as persons creating a new framework for Maori-Crown relations. In this chapter, Professors Varuhas and Geddes consider an additional relational innovation in public law of Aotearoa New Zealand, one that I didn't address in my chapter, but on reflection I probably should have, and that is the grant of legal personality to places. And they step through in some detail the granting of legal personhood by legislation for Te Urewera, which is an area of forested high country, the Wanganui River, and Taranaki Maunga, Mount Taranaki. All are both legal entities and property. They own themselves, as the authors say, and they're also capable of asserting their own rights and interests over themselves. Varuhas and Geddes say that while it's possible to see these innovations as largely concerned with environmental protection, because they seem to accord with the ascription of rights to nature, the better approach is to see them as reflective of the ways that Maori conceive of and relate to those places in a legal sense. And they say that in taking this view, these innovations are profoundly constitutional ones. They helped secure the settlement of historic treaty claims, for example, by shifting negotiations away from the question of who owned those sacred places, which the authors say is at its core a question of sovereignty, and towards a different way of thinking about land altogether, one that will change the way that these cherished places will be treated by all New Zealanders. So fittingly, perhaps, the last word in my brief comments, I have drawn from the Varuhas and Geddes conclusion. They say that the innovations they described, bringing Indigenous and settler laws together, quote, demonstrates the possibilities of public law acting as a bridge between worlds, which I think is just a wonderful way of saying what I believe, as many others do, that if public law can enable the building of a bridge at its frontier, this would be a really wonderful thing and something well worth pursuing. Thank you, everyone.
So let's move on then to the third and final act, if you like, of the launch event, which is the announcement of the 2022 Public Law Conference. And before announcing the host institution, let me just say a little bit about the series for those who are unfamiliar with it. So the Public Law Conference series are a biennial series of major international conferences focused on common law jurisdictions. The conference mission is to provide the leading international forum for public lawyers to discuss and debate the most important public law issues facing common law jurisdictions. And through this enterprise, we seek to foster a community of public lawyers drawn from across the common law world and from the academy, judiciary, legal practice, and government. So as many of you will know, the first two conferences in the public law series were held at Cambridge in 2014 and 2016, and the third conference was held at Melbourne in 2018. The fourth conference was to take place in Ottawa earlier this year, but unfortunately that conference had to be cancelled after a lot of work had gone into it due to the global pandemic. But the idea behind holding the conference in different parts of the common law world has been to bring in a wide range of perspectives and participants from different jurisdictions and to focus attention on public law issues pertinent to different countries and regions. So now I'm delighted to announce that the 2022 Public Law Conference will be held at University College Dublin in Ireland, and it will be held in July 2022. The conveners will be Professor Owen Carolan of University College Dublin and myself, and Dr. Sarah Fulham McQuillan will be associate convener, and she is also from University College Dublin. So I'm delighted that Professor Owen Carolan is here with us now, And I'm going to pass over to him to announce the conference theme and explain the importance of the year 2022 for Irish public law.
Good evening. Thank you, Jason. Thank you to the University of Melbourne for the invitation to participate in the event this evening. We're delighted to be hosting the 2022 event in Dublin. I've had the privilege to be involved in the events in the public law series previously, and to my mind, it's always been distinguished by the quality of the papers, by the coherence of the panels, and by the spirit of open, robust discussion and debate that takes place throughout the conversations through the conference and through the book being launched this evening. And we hope to continue that in Dublin, when in 2022 we'll be addressing the theme, the making and the remaking of public law. And that theme has been identified in part because it has special resonance for Ireland, because 2022 marks the centenary of Irish independence and of the first Irish constitution. And as a theme, therefore, it invites historical perspectives on the development of common law, but also on the challenges that were faced by Irish public lawyers in 1922 and that still echo for us today. The challenge of connecting public law to its social and political context, of building legitimacy and trust in times of conflict and disputes, the challenge of integrating common law with written constitutionalism, and also adapting common law or public law to new and evolving challenges, something that we've had to continue to do as notions of government, as technology changes, and as ideas of rights, citizenship, and national identity change. So we're very much looking forward, I think, to seeing how the papers address these themes, and we're very much looking forward to welcoming you all to Dublin in 2022.
Thanks, Owen, and it's great that you were able to join us. So that brings to a close the formal proceedings of this launch. I'd like to thank once again Justice Gordon for officially launching the book, and Professors Twomey and Gover for their reflections on the book, and thank all of you who joined us this evening. We're grateful for your support, and we look forward, as Owen said, to seeing you, as many of you as possible, in Dublin in 2022. So good evening.